Retrospective tax settlement, companies will have to indemnify the Indian government. Synopsis: The Central Board of Direct Taxes notified the final rules for settlement of retrospective cases after incorporating certain changes following comments from stakeholders on draft rules, issued on August 28. Think stock photos companies looking to settle their retrospective tax disputes would have to commit to indemnify the Indian government against any future claims in relation to their tax disputes. The indemnity and commitment to not seek any damage from the Indian government or its affiliates will have to be furnished by the company as also any other interested party, the government said in the final rules notified late Friday. Companies will have to file a declaration with the income tax authorities along with a board resolution or legal authorization besides an indemnity bond, the rules said. The Central Board of Direct Taxes notified the final rules for settlement of retrospective cases after incorporating certain changes following comments from stakeholders on draft rules, issued on August 28. The declarant and all the interested parties shall indemnify, defend and hold harmless the Republic of India and Indian affiliates from and against any and all costs, the notification said. They will have to file a claim within 45 days. The relevant Principal Commissioner of Income Tax has to give a certificate accepting or pass an order rejecting the claim in 15 days from receipt of the application, implying that the process can be completed in 60 days. They will have to file a claim within 45 days. The relevant Principal Commissioner of Income Tax has to give a certificate accepting or pass an order rejecting the claim in 15 days from receipt of the application, implying that the process can be completed in 60 days. Since the rules have been issued after detailed feedback from companies, it is likely that the cases could be settled quickly. The government had passed the Taxation Laws Amendment Act 2021 in the monsoon session of Parliament to settle retrospective tax cases, nullifying demands raised on transactions prior to 28 May 2012, which is when the controversial law came into force. The law provides a mechanism for settling litigation, including disputes at international forums, with Cairn Energy, Vodafone and 15 others. The government will withdraw all tax demands levied retrospectively and refund taxes collected, without interest and penalty. These companies can now settle these cases with the government under the framework within 30 to 60 days. Anyone filing the declaration before the income tax authorities and all interested parties will also have to fully assume the risk of any omission or mistake with respect to identification and procurement of authorizations and undertakings from any related parties or interested parties as provided in the undertaking, and secure the Indian government and its affiliates from any claim related to any award or judgment or any relief, the rules said. Interested parties will mean all the companies or entities in the entire chain of holding of the declarant till the ultimate holding company or entity, any person to whom the declarant has transferred any of its claims under any award, judgment, or court order pertaining to the relevant orders or under the relevant orders or granted any rights. Related party means affiliates, predecessors, successors, all the companies or entities in the entire chain of holding till the ultimate holding company or entity, subsidiaries, whether direct or indirect, assignees, agents, shareholders, present and future, owners, directors, officers, those providing financing, and employees of the declarant. Companies will have to withdraw all cases or appeals or any proceedings filed before any forum and provide a declaration to this effect. The declarant and all the interested parties shall irrevocably withdraw, terminate or discontinue all the appeals or applications or petitions or proceedings against the relevant order or orders and furnish evidence thereof and a declaration in the undertaking in Form Number 1 to the effect that it shall not, under any circumstances, reopen or file any such appeal, application, petition or proceeding in future against the relevant order, it said. The government has collected 8,089 rupees crore in taxes in 4 of these instances, including 7,880 rupees crore from Cairn. India has filed an appeal against the $1.2 billion award in favor of Cairn Energy plc by the Hague Court of Appeal in December 2020 and also against the arbitration award in the Vodafone tax dispute case. Cairn Energy has also filed cases in multiple jurisdictions to enforce the award.